It's Bay Radio International on a Wednesday, coming up to 4:15, mainland Spain, and AlicanteLawyers.es, Betha and Heredia in the studio this afternoon. It's Ignacio and Pedro. Welcome back, gentlemen. Are you well?
Good to see you. Buenas tardes.
We're going to talk about Spanish inheritance tax today. I know coming up later on the webinar, that it'll be talking about buy-to-let on the webinar today. What time is that? 5:30, is that right?
Yeah, 5:30, Madrid time. And it will be recorded for those who cannot attend.
So always available on the website?
Yeah, on the website, live TV, yes.
Okay, AlicanteLawyers.es. But turning to Spanish inheritance tax, then, what exactly is it?
Right. Inheritance tax, unfortunately, is a tax that the beneficiaries or the executor needs to pay within 6 months after a person has passed away. This means that you need to do the declaration, and depending on what community you are registered, you will have to submit, obviously whether you are a tax resident or non-tax resident, you'll have to submit that inheritance tax. Sometimes it's zero, sometimes it's a little bit of money, depending on your wealth.
So it's on property, money, and all kinds of assets.
Kind of
any other
assets.
assets.
Right. Yeah, and it will depend on the community you are in Spain, and the value of the assets. Now, we've been very lucky because here in Comunidad Valenciana, they just removed recently, 28th of May of last year.
Most recent, yeah.
And you only have one allowance of 100,000 euros, well, between husband, wife, and children per beneficiary, and then you get a reduction on 99% of the rest of any money that you inherit. So it could be probably very little.
It could be very little. Sometimes clients are amazed sometimes when we make a simulation, when they understood it was going to be like some percentage, like 10, 20, or 30%, and then they realize it's 300 euros or 200 euros.
Really? That low?
I mean, it's between spouses and children. I mean, with the first line of the family.
I see, okay.
And when it's different lines, obviously the taxes is different, but with spouses and children, that line is group one. That line is drop. The tax has dropped down a lot.
So the outcome could be quite good, but it's still quite a complex situation, isn't it? Inheritance tax. What about expatriates and non-residents, for instance?
Well, that's obviously complex. Where are the residents? If they are living in Spain or not, they live in Comunidad Valenciana or not, or different region. Where are the beneficiaries and where are the assets? It's not the same as a resident in Comunidad Valenciana and is receiving an asset, or is a resident in the UK and is receiving an asset which is in Spain, or maybe an asset which is in UK. And obviously the difference, sometimes it's not tax and sometimes it's tax. So obviously what we do is to plan and to make some simulations and talk about with clients about how to organize really this situation.
Yeah, actually, if you're in Group 1, at the moment is very good. Right, Group 1 is husband, wife, children,
so or immediate family,
or pareja de hecho, which are registered partnership as well. That's good. Okay, good advice if you're living with somebody long enough, you didn't get married, and probably you're thinking about if something happens to you, registering yourself as a partner. It will have benefits on inherit, and it's completely exactly the same.
So it has to be legal recognition, then.
Correct. Yeah. Correct. That brings, we've got clients that they've done it just because of that, because otherwise the inheritance tax is massive because it goes from 7% up to 37%.
So, for instance, a couple living together, if they weren't married and hadn't declared that they were in a partnership, they could the beneficiary could be paying up to 37%.
Correct.
But you can legally have your status listed as partnership.
Yeah, that's correct.
Without getting married, for instance, and therefore pay something like 7%.
Yeah, that's right.
The bottom line is probably you'll be paying up to 37% because you are just a friend, you're just a third party. Once you register, then probably it drops to zero or very minimum.
Very minimum.
Yeah, and that's good advice.
Yeah, and also we check about not just the inheritance tax, also about the future sale in case that you inherit, for example, a property. If you inherit a property, it's valued in, let's say, an example, 200,000 euros. And one of the spouses or children, they are receiving and they are paying very little tax. And sometimes there are some advisors say, well, let's declare a minimum about the value of the property in order to pay less. But whenever you sell, if you acquire the property in a value of 200, but maybe the market value is 300, then you have a gain. And if you have a gain, it goes from 19% to 28% tax. So as a capital gain, it's better in these situations. In many of these situations, it's better to declare perfectly the market that you understand is going to be sold, the property, so capital gains would be zero. And one other thing that we need to say is about the gift. When sometimes parents say, well, I will give my assets to children, and it's the same rules about the same line, same group. It's almost €0. But if you have a property that you bought in €200,000 and then you want to give it as a gift to your children, maybe now the value of the property is €400,000. Take care about what you're going to do, because the value of that property is, in this case, double. You do not pay, or maybe very, very little gift tax, but you, as someone who has given to your children a value of an asset which has a higher value, it is like you had an income, and then you have to pay income tax.
Income tax.
So be careful of that. If people say, I'm going to make a gift, it's very little, well...
Take advice, because as Pedro said, that's a big surprise. Income tax return, you are transferring something, you're earning nothing, but to the taxman, income tax return...
It's an income.
You're giving away an income, and tax office says, I'm sorry, you're giving it to somebody, but not to me. So then
he still wants his pound of flesh, doesn't he?
Yeah,
okay, I see.
But this is what we're talking about. Group 1 now. Brothers, sisters, nephews. There is not much allowance on it.
Mm-hmm.
I mean, probably €9,000 allowance per beneficiary. And third parties, big no allowance. If you give it in the will to an association, registered charity association, the tax is zero. So inheritance tax for them is zero. We normally deal with a lot of clients
like Cancer Association, for example.
Yeah.
That happens quite a lot, that go to cats or dogs associations, Mm-hmm.
And we normally, as executors, deal with that and then sell the property, wind up the estate, close the accounts, and then whatever is the net result, then you transfer into this association, but is net, so they don't need to pay. So that's quite nice in a way.
Mm-hmm.
But so you need to be careful here. Two things: what group you are in, and what Pedro said is very important. Donations. I mean, this is
because sometimes parents say, "I'm going to give it." I mean, we need to see the picture. We need to see the needs of the family. But sometimes it's just keep it yourself. Sell it, buy whatever you dispose, and then whenever you leave, then will be your children and will be very small tax anyway. So leave it as it is, and do not want to get a better scenario, because it's not going to be.
There isn't a better scenario. It's the tax man. Yeah. Okay. Yeah. Rather difficult, because everybody would have their own sort of perhaps different situations as well. So that brings with it its own complications.
It's very hard to be general.
Yeah.
That's right.
When they need to disclose their specific case, everybody will have a different scenario. But probably you could advise what is best for them, or what different options they have for them to choose.
We're going to have a webinar in 2 weeks' time. In 2 weeks it will be, because we are amazed about, I mean, obviously this is something that for us is day by day, but clients, they are amazed about, because they ask to us, how much tax would I have to pay on my children? And then we make a simulation, and they realize that it's very, very little. So we are going to make a webinar.
You've got to get the planning in, and you've got to do the due diligence on what may or may not happen. Not just assume that it'll be fine now that Valencia said that the first line of the family will not have to pay any tax. We're talking about close relatives, children, spouses, and parents who generally will be paying a lower tax rate. More distant relatives will be paying higher rates. And Moody, who's filming with us today, was talking about stepchildren, and I'm guessing they're in a different category than direct family.
That's exactly it. But you need to bear in mind, stepchildren will be the blood children of some of the couple. So it will be very efficient to draw up the will properly, so you could do it correctly, probably not paying taxes. So if it's the husband's children, then I understand. And if he agrees that the will should say X amount to the wife, X amount to his children. Because if he wants to leave everything to the wife and the wife passes away later on, the stepchildren will not get the allowance.
So they're not the first line then under that
For her.
circumstance, so I can see. So you can write this into a will, perhaps, yeah?
Yeah, that's correct. I mean, that's why it's so important to drop the will with somebody who knows about taxes as well. Because it's not only about your wishes, last wishes, what you want to do and who you want to leave it to. Is more about whether that's efficient as well and you're happy with that scenario.
It's important in those situations where imagine that there's a couple married that has children with different marriages before. It happens that they give everything between each other, and then substitutions the children, all of them, together in equal shares, for example. But we need to alarm and just obviously to explain that when someone passes away, they can change the will anyway. I mean, if I leave my assets to my wife, and I pass away, and my assets goes to my wife, then my wife can change and make another will, and maybe my children from a different marriage do not get anything. So
how do you get around that?
So we need to include some clauses in order to at least my assets that I give to my wife, at least those whatever remains until she dies, it will go also to my children. The ones, I mean, about this is an example, but we need to include those clauses in order to inform people that, this could be an issue. This could be an issue.
Well, the best way around probably will be there are different ways of doing it. I mean, you giving everything to your wife and anything left to your children, so you do two wills in one. So I leave everything to her. Whatever is left from my share, it goes because I do second will. So any leftovers, let's put it this way, goes to children. Or you could do, I think as Pedro said, going direct. So if you say, I give it to my wife and I give it to my children.
It's like the remnant, whatever is left. This is an example. It is just to notice that obviously in the wills, it's important to connect wills and obviously the tax at the end, whatever is going to be received. But obviously the wills are extremely important. But at the end, it's going to end up who are the beneficiaries, really.
But you brought a good point, because unless there is a good clause, if I leave everything to my wife when I'm gone, it's hers. So, I mean, according to, let's put it this way, British law or in general American law, which are free disposal of assets, if I give it to you, that will never come back. So if it goes to you and then you remarried and you could give it to somebody else, you need to be aware how much control you wanted upon that result. But there are ways to protect it, so it's nothing to panic on that. But just you need to be aware.
We've been talking about just one region generally, about the Valencian community. Of course, it's different in different parts of Spain, isn't it?
That's right. Madrid, Andalusia, and Comunidad Valenciana, where we are, in Valencia region, have dropped down almost to zero. I mean, have dropped down 99% the quota to be paid. So it's 1% of the quota that should be paid. And obviously it's almost zero because cannot be erased because of the law. But they have dropped down almost to zero. Rest of the communities, they have different rules, and obviously this, for example, Catalonia is it is as it was Valencia region a year ago. Balearic, it's also has
similar
also
to us?
it's similar but not the same exactly. But obviously this is regional and obviously something to see.
But you need to be aware as well about, some people get confused. The will of a national, they need to choose the applicable law. So, for example, Pedro and myself, we have no choice rather than comply with the Spanish civil code. Okay, so we cannot leave everything to our wives.
Exactly.
Two-thirds
goes to our children for sure.
However,
1/3 could go to whoever we want, or could be also to our wife. But 2/3 goes.
Those
to
are the
children.
rules for Spaniards.
Exactly.
Yes, for Spaniards.
And whoever is resident in Spain, unless make something, Alex, do something in a will be also Spanish law. So this is why we highly recommend.
So if you're an expat, you can choose.
You can choose.
Exactly, you can choose.
But you have to do this. You have to put it down in writing.
You have to sign a will.
Exactly.
Otherwise, if you pass away without a will and you're resident,
will be Spanish law.
it will be Spanish law. And
Right.
probably that's not the scenario you want.
What about if somebody previously had made a will in the UK, for instance?
The property, yeah.
Would that still apply? Or
No, the European Act, it was approved in 2012, and then it was valid in terms of starting to be applied in 2015.
Well, Britain was still part of the European Union, but it's not now. So does that change things again?
It will be like a probate, like a how to say, it's like a, I forgot the word is, in order to check the will, it was said that it was going to be the applicable law to be the English law, because the European law Act, it says that needs to be said expressly to say that. Obviously, if it's a UK will, it's not something that, but it's not said. It will not be said that because it's resident in the UK, it's not resident in Spain. And now things in that situations may be open to interpretation. And many of them will say if it's been signed before 2015 or 12 in this case, and nothing says about the European Law Act, I think will be in many occasions will be rejected.
Because you're putting the scenario of not having Spanish will, having a UK will,
and be resident in Spain.
And be resident in Spain.
Because if he's not resident in Spain, it's not a problem. Because he's not resident. But if he's resident in Spain, then terms of Spanish law is applied. Unless it's chosen expressly according to European law, in this case, UK law, in this case.
And sometimes you need to think, you've got these cases that they have 3 passports. And then you could do a little bit of shopping here, because you could say, what law protects you better?
Yeah.
You know, we have some people who are Spaniards, Americans, and Norwegian, you know, the 3. And we double-checked with the notary the other day, and they said, as long as you are national, you could choose the nationality, which gives you a lot of freedom. That's the word. Depending on your nationality, it gives you freedom of free disposal.
Exactly, because UK law, for example, in this case, it gives you a liberty. Some other laws not. For example, Italian or Latin is different, like Spain. Or even Norway. Norway has some specifics, for example, but UK is fantastic.
Yeah, the problem is the forced heirs. The laws protect forced heirs. So that will happen right now with Iceland as well. Norway probably, as you said. Sweden probably as well. So they really protect family. So you cannot give away to whoever you want if you have family related, you know. So taking that into consideration, I think nationalities are very important to make a proper will as you wish. And so you have a lot of things to think about. You have the nationality, to choose what applicable law, because if you don't choose, you have an issue. The tax, the regions, and
also where the beneficiaries are. I mean, we said about that. What if
whether they're not in Spain?
I mean, they're in Spain, but the assets are in Spain. Then will be some tax to pay. But what if the money can be moved to wherever they are? Maybe there is no tax there. What if you're going to receive like 300,000 euros or an asset that is in UK and the beneficiary is in the UK, will not be taxed in Spain, will be taxed in the UK. But here, I mean, all those things need to be checked and seen, because situations may be able to be available for.
There might be a better way of doing it, perhaps.
Yes, definitely.
To avoid paying so much.
Yeah. I mean, it's always preventing these scenarios, like doing simulations on taxes. I always recommend people looking ahead and seek advice, because you could save so much problems and money.
Yeah,
if
I mean, there
before.
are not just the differences that we've been talking about, but it's, you know, whether you're resident or non-resident, there are big differences as well. I mean, how regularly should somebody look at their will to make sure that they're still pretty much up to date? Pedro was mentioning some dates there, 2015, for instance, and perhaps if somebody made their will before that.
Well, if someone made the will before that date, I mean, it's 17th August 2015 when it will start being valid, and this act is from 2012. But before that, those dates, I would recommend to check it. Yeah, absolutely.
Yeah, and even if personal circumstances of people change, if you get divorced,
of course,
you should redo your will, or at least think through. If your relative passes away, whether that's the most efficient way to do it. And a lot of clients say that the circumstances have changed. And I would say, to have a look through. Is not expensive to go.
I was going to ask actually, how much would it be to have your will reviewed, for instance?
We normally charge for the hour consultation to do simulations with the tax and the wills. But it really depends on people. At the end of the day, you will charge a minimum fee, 150 euros plus VAT, and it will have our accountant, Pedro and myself, and then run through everything. And then you take it from there.
That's not a great deal to pay for a peace of mind to make sure that what you want to happen on your sad demise is what happens with your assets.
Exactly.
Yeah, it's official.
And I remember, I think it's 2 or 3 weeks ago, someone came to revise a will, and I revised it, and it was before that date, but it was okay. It was okay. I revised it, I interpreted it. I said, well, it expressly says this, and there is going to be any change. So for us, it's not. I mean, if I see a little situation that can make me a risk, I don't mind, because to make a will or it's not a big deal really on money, so it's better to do it. But if we see that it's not needed, it's not needed. I remember also about power of attorney. A week ago, a client comes. Someone has said to me to make a power of attorney. To do what? What if it's needed or not? Or because some representative of financial institutions have said that. Well, there's no need, because sometimes we need to know what is the circumstances, what is the need of the people, in order to understand.
Well, I guess people generally,
if there is no need, so wait, there's no.
As people get older, they do kind of worry that perhaps it might not be in the right way to be able to make some of these difficult decisions. In those circumstances, perhaps, where people worry about the future.
Nevertheless, the power of attorney is a good tool between husband and wife to husband. But probably not for the specific situation.
In general, is needed. We recommend it in general.
But this is good. This is honest advice. If there's no need, there is no need for you to do anything. But when personal circumstances change, I think it's worth having a word with your lawyer, and then take it from there, because on a daily basis, we save so much money to people, and this is what really
that's what it's about, isn't it? You don't want big bills going to your relatives when you go, and that's certainly what people want to avoid. This afternoon, we've been looking at inheritance tax and wills and probate. What exactly is probate?
That's a good question. Well, the probate, if we're talking about call it in Spain, the probate we call herencia o aceptación de herencia, right? Or which means you disclosing the assets, you being the beneficiary, and you accept it, the inheritance. This is what we call probate in Spain. In the UK, going to probate is going through the courts to be named and being granted officially the beneficiary. Okay. Well, in general terms, probate is going through probate is accepting pretty much, being named and accepting the process. In Spain, if you haven't made a will, they will ask you for the probate in the UK if you're British, or the probate in the States, or the probate in the home country. So that means somebody, an administration, officially naming you as beneficiary, and then the Spanish administration will take it for granted that this is legal. Otherwise, sometimes it's very difficult for the public notary to say, with no will here. Well, we even have cases, no will here, no will in the
Anywhere
UK.
Else.
And then you need to do an affidavit of laws, and the laws of interstate law will tell you who's the beneficiary.
It's like a no will and affidavit in order to make whoever, obviously someone expert, in order to declare who are the beneficiaries. Really to decide who are the beneficiaries, really, with the probate. And if there is no will in Spain, we have another step, which is the declaración de herederos, which is really the probate and as Ignacio said, acceptance of inheritance is with the will, is everything together. Really, is in the same step. So it's really, just to know who are the beneficiaries and what is the applicable law. And if obviously, when you go to a notary here, what is the applicable law in Texas? What is the applicable law in in Australia? And what is the applicable law in specifically, for example, in Ireland, or if we say some specific area. So that's something that needs to be also set and checked.
As part of the will, you need to name your executors, right?
Sure. This is very, very good and very efficient, especially if you want to spread it out specific ways. Probably if you don't have children, then you tell your executor what you want to happen or what you want him to do once you pass away. And that's important. You can name it in the will. I mean, we could do international wills here in Spain and covers Spanish assets and different international assets. We are, in general terms, our wills, we are executors of the clients. And actually, we are official administrators in the courts. Name official.
We make reports, we make the division of inheritance whenever there is a litigation on this. Yeah. So we are like, we make experts on this. And
expert on executors. When you have a litigation case and they want an executor official name by either the notary or a name either appointed by the courts, we are on the list.
Okay.
It brings good value to...
And as we know at that point, that view on the courts, what we do is to prevent our clients to go on that view and go on courts. I mean, we prevent absolutely everything. We on terms of wills and beneficiaries, whoever is going to be received.
But I think it's good value to have an executor like a law firm to do, and you tell them exactly how you want it happening. I mean, the official information will be provided to the will, but you could give a lot of instructions what to do if this happens. So when it goes husband to wife to husband, okay, fine. But when it goes to you want the Cancer Association or you want charity, any other charity, then the executor is a big job because it needs to deal with everybody.
You're managing it on behalf of the charity then.
And I think that's good thing to perform your wishes and do what you want. And yes, we have fun.
And identify all the assets, and we always say to clients, let us know what are the assets, because sometimes we cannot find them.
No, that's the problem. I mean, in the will, you will never say how many assets you've got and where and what. But it's important, and I always say to
at
clients,
least the beneficiaries know it.
Yeah,
even though they don't say
know where to contact. Or the executor should have a letter of instruction. When this happens, this is who you need to ring, or you need to contact this bank, or that, because otherwise it's not public.
Yeah, we might have a bank account that somebody doesn't know about.
Yeah. Exactly, that happens a lot.
Lucky banks.
Yeah.
No, really, because what do they do with it?
It happens a lot. Yeah.
Is money there, sitting there forever? And
yeah.
If nobody claims, they repossess that money. That's the truth, because I never heard them giving to somebody.
So it's important to make sure that you've listed everything. Exactly. But you don't actually have to list that in the will itself. You can do that with the executors.
Yeah, correct. I mean, you don't need to put it... I mean, you could if you wanted.
But it's not set.
But it's unnecessary because you could have today X amount of money and tomorrow you could have different. Yeah. But it's important instructions for your children to know.
It's important to get all of this together and done earlier rather than later, and also check if your will is a certain amount of time, or you did it a long time ago.
Yeah, I always say
just to check.
I always say do it at least once, even though it's a simple will. At least you have one sorted. Mm-hmm. You could always change any time, but sometimes we're lazy to do it. I'm not ready to die yet.
None of us like to think about it. That's right.
I'm not ready to go. But I think you do insurance, and probably you don't do wills. And this is your own insurance, because you tell the people who you want to receive your inheritance. So.
You want the way you want things to go when you pass.
Yeah.
So you can find out more about the Spanish inheritance tax and calculations on inheritance tax and the like at alicantilawyers.es. It'll bring you up on the Pedro and Heredia website, not just in English and Spanish, but a number of other languages as well for our other friends around Europe. And you can always get in touch here at Bay Radio if you want to speak to either Ignacio or Pedro or one of the team, or go via the website pedroandheredia.com at alicantilawyers.es for ease of that. And we'll chat again in a couple of weeks. In fact, next week I'll be speaking to Antonio with Romy from Villa Lux. We'll be talking about Dutch properties, second home ownership for Dutch people. But we'll be back again in a couple of weeks.